Welcome to Our Issues Birmingham. Today's guest is a very dear, I don't want to say old friend, I will say longtime friend.
Right.
How about that?
That's a good way to
Of
say it.
mine, Knee Bear is the way I like to call it. She has a different name, but we'll just go with Knee.
That's great. That's great. That's easy.
It's easier to pronounce. She is a family law practitioner here in Birmingham, but they also have an office, Bear and Rush, in Shelby County, which is Columbiana, Alabama. Welcome, Nee. It's good to have you here.
Nice to be here, Tommy.
It's good to see you outside of the office setting.
Yes, it is. Besides in court.
So what's the deal with family law? Because I've always felt, and I'm not making light of the stresses that come with the breakdown of a marriage, but it would seem to me that we need to make it harder to get married and easier to get divorced, where it seems to be the exact opposite.
It is.
What contributes to that? The difficulty it is to just get through a divorce. I mean, you've got competing, you have emotional issues, you have financial issues, you have child issues, all in this bubble of I don't know what to call it, just legal things. It seems like lawyers are not the best way to resolve those differences. I'm not trying to get into your business.
No, I think that a lot of people think that the system should not be adversarial. Nonetheless, even with the reforms that have been discussed widely for the last 30 years, it remains adversarial because you're involving everything that matters to a human being. You're talking about your children. You're talking about, am I going to be safe after a divorce? Will I have money to get by? You're talking about how frequently will I be able to see my children? Am I going to lose my business? Am I going to, and still there is that feeling of, am I going to be able to get by among a lot of people, financially get by? After it's all over and done with. So it's a tremendously stressful situation always because people are afraid. That's really underlying all those issues.
Fear.
Because fear of losing your children, fear of losing your money, fear of losing your home, fear of losing that family.
Fear of the unknown.
Right. It really is.
And the future.
And as a result, the clients are so stressed out frequently that you have to really attempt to have some sense of calm and reassurance because people are not acting like they would typically act.
And I wasn't making light of the institution of marriage when I made the comment I made about it's so difficult to get divorced. But quite frankly, we have about 50% divorce rate these days. Right. Is that universal or is that just Alabama?
Oh, no, that's universal. It's gone up and up. I started practicing 30 years ago, and it's gone up and up and up through the years since the time I started practicing. It is less of a commitment feeling than there was 30 years ago when I started. There was more of that people still trying to hang on and see if there was a way to work things out.
With or without kids?
Well, generally it's probably, I don't know, maybe it was with and without. It's just, it depends.
Kids certainly change the dynamics.
They do.
And the delay in getting a divorce, which frustrates people because if they've made the decision to move forward or to move in a different direction, getting to where they want to get is hampered by the court system because simply we don't have enough staff.
Well, you know, Tommy, what part of the problem is that so frequently the decision to make to go through a divorce is so difficult for some people to get to. They've been thinking about it for a year or 2 years or longer. And the day they walk in my office frequently is the day they're, okay, I want this to get filed. I want it over with now. And then they have the delayed process of having to work through the judge's dockets to have their case reached. There are some judges whose dockets move along more rapidly than others. certainly the move towards mediation has been what the judges would so prefer.
And describe what that means.
Well, mediation is just another word for alternate dispute resolution, which is what it started out being called, ADR. And the judges feel so strongly that people need to settle their own business, particularly with their children, with everything in a divorce, and they push people to go through mediation. We have mandatory mediations that are set at the courthouse whenever you have a case on the docket, and you go, and there are mediators who are lawyers like me that they've asked to do help with mediation. We're there, and we try and tell people, look, you've got this judge. There's every likelihood your case is going to be delayed. You can control this, and we're there to try and help.
Mm-hmm.
So you don't have to hire a mediator if you can avail yourself of what's available.
So, for the most part, a mediator is a lawyer,
right,
who practices family law,
right,
who's familiar with issues that come from the dissolution of a marriage and kids, who tries to get between the parties and bring them together, generally speaking, in a compromise.
That's right.
Of some sort.
That's right.
And somebody has to give.
You did the better explanation than I did.
Well, I don't think, I think you're there,
mm-hmm.
but I don't think people appreciate that what you said hit the nail on the head, that people need to work out their differences amongst themselves and not involve government.
That's right.
In it. Don't go away. We're going to get back with Nee Bear and ask some other questions that are near and dear to your heart. We'll be right back. Welcome back to Our Issues Birmingham. I'm Tommy Spina. I'm talking with lawyer, I like to call you lawyer, I don't like attorney, lawyer Nee Bear. Nee is a family law practitioner. We've been talking about the dynamics, personal especially, of the dissolution of a marriage. There's some things that have developed over the years, one of which I'd like to talk about just briefly. Back when I first started practicing law, as any young lawyer, before I became a criminal defense lawyer exclusively, I would do whatever I could do to generate revenue.
Sure. And
I handled divorce work in those days. And this is in the early 80s, late 70s. Mm-hmm. It was always presumed that in a custody battle, that's a horrible word for that.
That's what they are.
I know.
Unfortunately.
But in a custody situation, the mother was always presumed to be the proper party to be the custodial parent. So take us through the evolution, because that's not the way it is anymore.
No, it isn't.
And what brought about that change, and where are we now with that issue?
Well, Alabama is rather well known. We have the case that said we had to have gender-neutral statutes, which involved, first one that was struck down by the Supreme Court was that the statute originally said only women could get alimony. So they got rid of that, and the next step that they took, the Supreme Court did, was to strike down the tender years presumption because it favored women. That was the gender reason, and that underlay the
and this all
legislation.
Spins out of protected classes of people.
That's right. That's
like
right.
Men,
mm-hmm.
whatever the issue
mm-hmm.
is.
So when what the tender years presumption, and it was called the tender years presumption, was that a child who was under the age of 7 always belonged with the mother, absent some
no matter
horrible, absent some mental illness or something like that would have prohibited a court from doing something like that. But it was strictly women under the age of 7, children belong with them. But when I started practicing law was when the case that the Supreme Court enacted, striking down the tender years presumption, was enacted. So I've seen it used to be you would be horrified if you had an older judge because you were completely concerned with that prejudice that they had been used to doing when before the tender years presumption was struck down. What I think all courts know now and have acknowledged now, men can be as wonderful parents as any mother can be, anytime. But I don't believe there's a preconception on in any of the judges' minds that I deal with or that I'm in front of that do consider the mother should have the child first, last, and always.
So it's an even playing field.
It really is.
And can you measure, just a sophisticated guess, in how many instances there is the father gets custody, or are you seeing more shared custody arrangements? And what is shared custody?
It's really tending to more shared custody. You know, the legislature in Alabama. I taught law school for domestic relations for a while, so I tend more to talk about the overview of things. But for quite some time now, the issues that are before the court are certainly gender-based. Sometimes but typically children do well with both parents being involved in their lives. And when the joint custody statute was adopted, the state said in 1987, it is critical that in the event of a divorce, there be frequent and continuing contact with both parents, particularly following divorce, was what it said. And then that was later added to by the Relocation Act, which was adopted. But at any rate, a lot of the judges really are tending to do a lot of week-on, week-off visitation, which is occurring with some regularity these days. I think that sometimes the judges have, instead of doing, no child could bond with a parent if they saw him 4 days out of a month, which used to be the presumption. Friday.
And after all.
Right. Every other weekend, or first and third weekends from Friday.
That's the way it was when I was doing it.
No more.
And the overarching concern is what's best for the child. Should be.
Supposed to be.
Yeah. But sometimes it's not. Now, you made reference to the relocation statute. Now, that didn't exist back in my day.
No.
So I understand there's some rules now that prohibit a parent from moving.
Well, again, it was the legislature said once again, we're going to act in the best interest of children, and it's a public policy of the state of Alabama that children should have frequent and continuing contact, particularly following a divorce, with the children, but with the parent. But the Relocation Act really was the real name of it is the Alabama Parent and Child Relationship Protection Act. And what the Relocation Act, which was passed in 2003 through the legislature and enacted in that year, was there was a presumption if you moved more than 50 miles away from the court of original jurisdiction, the court that had the case that entered the divorce, you had to provide the other party with 45 days notice. The party has a right to object to the relocation. And then there are a set of factors that the relocating parent, or the one who wants to relocate, has to meet. And there are 18 factors.
Oh, my.
That are very, all of them very important. You can't just pick up your child and say, I don't like you. I'm getting out of this state and you won't see your child again. That's not a possibility.
Well, it definitely requires cooperation amongst the parties in co-parenting.
Yes.
But we're going to talk about that and one other thing when we come back from break.
All right.
So don't get up and leave.
I'm out.
We're not finished. This is Our Issues Birmingham. We'll be right back. Do not go away. Welcome back. Talking with Nee Bear about children, divorce, custody. But you know who gets left holding the bag, and I'm closer to being one of these, and that is the grandparent.
Right.
Alabama, for some unknown reason, doesn't really give the grandparent much say-so in a divorce action. It's still their grandchild.
That's right.
We had a statute. It went away.
We've
Then
had-
another one came back. It went away. Explain that.
It's about its sixth iteration that they passed through the legislature, and it's not just Alabama. Alabama has to follow federal law, and a case was decided by the Supreme Court of the United States, which was about a grandparent statute, which was struck down by the court of the Supreme Court. It was a Washington statute that allowed the grandparents to visit with children, and in that case, there was a mother who did not want her child to have any communication with and the father had died, with the grandparents
Of the deceased father.
Of the deceased father, and there was such a strong presumption that grandparents needed to be in children's lives, which I believe they do need to be unless they're malicious for some peculiar reason, which is seldom the case.
Again, best interest of the child.
Best interest of the child. With the case that was decided by the Supreme Court, it's not just Alabama. Every state has been trying to adopt statutes that will get past the federal case, which is what guides state acts, as you know. And the reality is, if a parent doesn't want their child to have a relationship with a grandparent, the grandparent, when they move to try and get visitation with the child, has to show, and this is a heavy burden of proof, that the child will be harmed by not having visitation with a grandparent.
How do you prove a negative?
I don't know, and it's
I've
hard
never
to
been
do.
able to do that.
I know it's very difficult to do, but judges who listen to the testimony get to see what the grandparents like, what the children are like if they are brought into court.
So there is a way in Alabama for a grandparent to have standing?
They have standing. They have standing because the Act gives them standing. But whether they get that, whether they're able to prove that the child is harmed,
if they don't
have visitation, is the heavy burden of proof that you have to meet.
Again, if people could just come together,
right?
This reminds me of another saying: if it weren't for lawyers, we wouldn't need lawyers.
I guess that's true.
If you get into the adversarial nature of, it's like throwing gasoline on a raging forest fire, especially with all the bubbling issues, emotional, financial, that we talked about earlier. So what is, now, don't get me wrong, if parties come to terms and come to your office and together even, and say, I know you can't represent both sides, and somebody has to sign off on, you're not their lawyer, just the other person's lawyer. But if people want to come together and present you with what they've agreed to, you can be divorced in Alabama relatively quick.
Rapidly. There's a 30-day cooling off period. If somebody comes into your office and says, okay, we want a divorce, here are the terms we want to have in the divorce, and I draw it up, and I have to advise the other, whichever party, that I can't represent both of them, but I can draw papers.
So in that instance, and the judge being available to sign it.
Well, you file it, and then it has to sit on the judge's desk for 30 days.
30 more days.
Which is the cooling off period.
Oh.
Or if the case has been filed and 30 days have passed, then the judge can sign it.
And that still happens occasionally.
Occasionally, yes.
So that's not litigation. But if you're in the litigation universe, what kind of time frame are citizens looking at when it comes to the dissolution of a marriage? Let's assume it has 2 children and it's going to take some time. I guess it's different in different counties.
It is different by counties.
But let's talk about Jefferson County.
Jefferson County has 3 domestic relations judges in Birmingham, and there are 2 judges that hear domestic cases largely in the Bessemer division. So, but they're not just solely there to hear domestic cases. So we've got the 3 judges here, and only about 5 counties in the state have got solely domestic relations judges. And their dockets are going to typically be loaded, and they're going to take a while to get tried in a town as big as Birmingham is.
Are we talking
A year
12 to 18 months?
at least. At least if there's not controversy, a lot of difficult issues that you have to try and resolve before you have to go into court. And there's some people who just want to fight. One person wants to fight, and there's not a whole lot of control we have over what we can do at that point.
And in the process, they're just spending more money
That's right.
and diminishing the assets that
That's
they've
right.
accumulated during their marriage.
That's exactly
So
right.
the bottom line is, if you didn't get along in your marriage, you're probably not, or as I say, give your divorce a chance to work. You know,
Mm-hmm.
a lot of people still fight.
Yeah.
That's
Yeah.
just the nature of the beast. I
And
guess.
you know, they've done studies and they've shown that women tend to, and I tend to remain angry for 10 to 15 years following a divorce, whereas men recover more quickly.
I think we'll end on that note. Speaking of presumptions, this has been Our Issues Birmingham. Nee, thank you so much for being with us. We'll see you next week.
Play Eric Amarola's Race Day Mix.
If you love them enough to crawl into a play place to get them to come down, then surely you'll check nhtsa.gov/the right seat to make sure they're in the right car seat.